Some land doesn't just have an address, it has a history. My family has owned our 48 acres in rural Tennessee since 1923. My great-grandfather cleared it by hand. My grandfather built the main house from timber cut off the property itself. My father raised 4 children on it, and I buried both my parents under the oak tree they planted together the year they got married. This land is not a property. It is a legacy. Barbara Fenwick moved into the newly developed subdivision, bordering our eastern fence line in 2019. By 2021, she had somehow become president of the Maplewood Ridge HOA, a homeowners association that had been created entirely for the new development, not for land that existed decades before their first foundation was ever poured. But Barbara had ambitions that exceeded her jurisdiction. She sent us a certified letter in January, claiming our property fell within the HOA's expanded boundary zone, a term she had apparently invented herself, and that our barn, our equipment storage, and our family cemetery were all in violation of community standards. She put a timeline on it. 90 days to comply or face legal proceedings. My hands were shaking when I read it. Not from fear, from fury. My daughter, who works in property law in Nashville, drove down that same weekend. She pulled every deed record. Going back to 1923, she contacted the county recorder's office. She requested the original HOA formation documents and boundary surveys from 2019. What she found was simple and devastating to Barbara's case. Our title predated the HOA's legal existence by 96 years. An HOA cannot retroactively absorb land that existed generations before its incorporation. Not in Tennessee, not anywhere in the United States. We requested a meeting with the county sheriff's office, not to file a complaint, but to have our title officially documented against Barbara's boundary claim. Sheriff Monroe reviewed everything personally. He contacted the county attorney. He then sent Barbara Fenwick a formal written notice stating that any further attempts to enforce HOA authority over pre-existing titled property would be treated as harassment and potential deed fraud. Barbara's 90-day ultimatum expired quietly. She has never sent another letter. Our barn still stands. The equipment is still stored exactly where my grandfather left it, and my parents still rest beneath that oak tree, on land that was ours long before Barbara Fenwick ever learned to spell HOA. Some things you simply cannot take from a family, especially when the sheriff has read the deed.